Welcome to the Deep Dive. We've got some excellent material you sent over from the University of London, their guide called Topic 2 Trusts, the Basics.
Yes, it's great stuff.
It really is. And it's fantastic that the university makes these resources available for students. We should stress right at the start, this discussion is purely for educational purposes, using these materials to help understand things better.
Absolutely. Just unpacking the core ideas.
Exactly. So our mission today is really to, get to the heart of what a trust actually is, why people create them, and how they fit into the whole legal landscape.
And we'll be making sure to flag those key concepts, the important case names, maybe even the judges who made the big calls.
Yeah, anything to help make this stuff stick, especially if you're studying it. So we'll cover equity first, define a trust, look at the reasons for creating them.
Their legal effect, those trusts that just sort of pop up by law.
Right, and finally how trusts are different from things like agency or contracts or debt. Sound good?
Let's dive in. To really get trusts, you absolutely have to start with equity. As the uni materials point out, the English legal system, historically, it had these two streams running side by side, common law and equity.
Like two different ways of doing things.
Pretty much different toolkits for solving legal problems. And originally, they even had separate courts. You had the Court of Chancery dealing with equity and the common law courts for, well, the common law stuff.
Until they got merged.
Exactly. The Judicature Acts, 1873 to 75, brought the courts together. But, and this is crucial, even though the courts are unified now, the actual principles of law and equity are still distinct.
Oh.
Lewis and L.J. made that really clear quite recently, actually, in Brake v. the Cheddington Court Estate. He basically said the administration is fused, but the underlying principles haven't really merged into one blob. They're still separate bodies of rules.
So if you have these two sets of rules, law and equity, and they conflict, what happens? Who wins?
Good question. There's a very old rule for that. It goes way back to the Earl of Oxford's case in 1616.
1616.
Yeah, ancient history, but still relevant. It established that if there's a direct conflict, equity prevails. Equity gets the final say. And that principle is still baked into the system today. It's in the Senior Courts Act, 1981, Section 49.
So equity trumps common law.
In a conflict, yes. But it's really important not to see equity as replacing common law. Maitland had that famous line.
I think I know this one.
Equity without common law would have been a castle in the air, an impossibility. Equity needs the common law to build upon. It refines it, supplements it, fills the gaps. It doesn't exist in a vacuum.
Right, it adds nuance, maybe fixes rough edges.
That's a good way to put it. It provides remedies and approaches the common law didn't originally offer.
You mentioned the fusion debate earlier. Yeah. What's that all about? Did they merge or not?
Well, that's the debate. Did the Judicature Acts just merge the courts, meaning one court system applies both sets of rules, or did they actually fuse the rules themselves into one coherent body of law?
So administrative fusion versus substantive fusion.
Precisely. Most people, including judges like Lewis and L.J. again, tend towards the view that it was mainly administrative. You know Ashburner's analogy. Two streams flowing side by side, but their waters don't really mix.
Okay, I see. So the principles remain distinct, even if the judge applies both.
That's the dominant view. It does raise interesting questions for you, though, thinking about modern law. Are all those historical distinctions still useful? Do we need two separate toolkits?
Something to think about. Now, the word equity makes me think of fairness, just doing the right thing. Is that what it boils down to?
That's definitely where it came from historically, trying to mitigate the harshness of common law. But, and this is vital, it's not just about a judge's gut feeling of fairness anymore.
Okay.
It's developed into a proper system of rules with its own precedents. Lord Eldon, way back in G.V. Pritchard, worried about exactly that equity changing depending on who the chancellor was, like the length of the chancellor's foot.
Right, you wouldn't want justice to be that subjective.
Exactly. So equity operates on established principles, even though its goal is often to achieve a just outcome.
The materials also mention unconscionability. That sounds important. What role does that play?
It's a huge concept in equity. Unconscionability is often the trigger for equity to step in. It basically means conduct that's so unfair, so against good conscience, that the court feels it has to intervene.
Can you give an example?
Well, cases like BCCI v. Akindo or Pennington v. Wayne and Pitt v. Holt, they all grapple with this. When does someone's behavior become unconscionable? Is it a strict test or more of a general standard?
So there's debate around it.
Oh, definitely. It gives equity flexibility, but it also means there can be uncertainty. It's a key area to watch if you're studying this. What exactly is so bad it shocks the court's conscience?
And what about these equitable maxims mentioned? Are they actual rules?
Not quite rules in themselves, more like guiding principles. Think of them as sort of slogans that capture the spirit of equity.
Like equity looks on that as done which ought to be done.
Exactly that one. Or equity will not assist a volunteer. They aren't binding laws you can sue on directly, but they inform how judges think and apply the actual rules found in cases.
So they guide the reasoning.
Precisely. You see it in cases like Coucher v. Coucher. Bagnall J, in that case, really stressed that even when dealing with fairness, like in family property disputes, the decision has to be based on established legal principles, not just some vague sense of what seems fair. The maxims point towards those principles.
Okay, that helps clarify equity. So we've got the foundation. Now let's get to the main event. What, legally speaking, is a trust?
Right. So at its simplest, a trust is a setup where property could be money, land, shares, anything really is held by one person.
The trustee.
The trustee, exactly. But they don't hold it for themselves. They hold it for the benefit of someone else.
The beneficiary.
For beneficiaries.
Plural.
Correct. Or sometimes for a specific purpose, like a charity. The person who sets it all up is called the settlor. And the property itself is the trust property or trust assets.
And you mentioned non-charitable purpose trusts are generally void.
Yes, that's a key point. Trusts generally need human beneficiaries who can enforce them. There are exceptions, but private purpose trusts are usually invalid.
Okay, so why bother with this setup? Why create a trust? If I want my niece to have my shares when she's older, why not just wait and give them to her?
Well, trusts offer some real advantages. Your example is perfect in capacity. Your niece might be too young to manage the shares now. So you put them in trust, and a trustee manages them for her benefit until she's old enough.
Makes sense. Any other reasons?
Oh, yes. Flexibility is a big one. You could set up a discretionary trust where the trustees have the power to decide who among a group of beneficiaries gets what and when, depending on their needs.
So it adapts to changing circumstances.
Exactly. Or you can split the enjoyment, maybe give the income from an asset to your spouse for their life, and then have the capital passed to your children afterwards. That's done through a trust. Pooling assets is another common use. Think of big pension funds. They are essentially giant trusts pooling contributions from many people for investment.
Right. And asset protection.
Yes, potentially. If set up correctly, and before any trouble arises, a trust might protect assets from, say, the settler's future bankruptcy. Though you have to be careful there, it can't be done to deliberately hide assets from current creditors.
And tax planning, I assume.
That's a major driver, yes, though the uni materials rightly say that's a whole complex area in itself, probably beyond today's basics.
Okay, understood. Now, this idea of the trustee holding property for the beneficiary, you hear about legal title and equitable title. Is it like the ownership is split?
That's the traditional way of explaining it, yeah. The trustee has the legal ownership. They're the owner on paper, can deal with the property, but the equitable ownership or interest belongs to the beneficiary. They have the right to benefit.
So dual ownership.
It's a useful shorthand, but some argue it's maybe not quite accurate. People like Burroughs, and Lord Mance mentioned this in Akers v. Samba, suggest maybe the entire ownership, legally, passes to the trustee.
Oh, so where does the beneficiary's right come from?
It's seen as an equitable right that's sort of imposed on the trustee's legal ownership. The beneficiary gets rights against the trustee concerning the property, rather than owning a separate chunk of the property itself. It's a subtle but important distinction in theory.
Interesting. Okay, the materials also talk about trusts arising by operation of law. That sounds automatic, not set up by a settler.
Exactly right. These aren't trusts someone deliberately creates with a trust deed. The law itself imposes them in certain situations. Constructive trusts are the main example here.
Constructive trust. Why would the law create one?
Often to prevent someone unfairly profiting from wrongdoing what equity considers unconscionable conduct. A classic example is FHR European Ventures v. Cedar Capital.
What happened there?
An agent took a secret commission, basically a bribe. The Supreme Court said the agent held that secret commission money on a constructive trust for their principal, the person they were supposed to be working for. The law stepped in to say, nope, that money isn't really yours.
So it's like a remedy.
In many cases, yes. It forces the person holding the property to hold it for the benefit of the person who's been wronged.
And what about the other type mentioned? Resulting trusts.
Resulting trusts also arise by operation of law. They typically happen when property is transferred to someone, but it looks like the person transferring it didn't actually intend for the recipient to get the full benefit.
Like if I pay for a house, but put it in your name.
That's a classic resulting trust scenario,
Yeah.
yes. The presumption might be that you didn't intend to make a gift, so the person whose name is on the deed holds it on a resulting trust for the person who paid. Though, like many areas in trust, there's quite a bit of academic debate about their precise basis and how much intention really matters. We'll definitely need to unpack these more later.
Okay, so we have express trusts people create, and then constructive and resulting trusts the law creates. Now, how do we keep trusts separate from similar ideas? Like agency. An agent handles things for a principal, a trustee for a beneficiary.
Sounds similar.
It does sound similar and sometimes overlaps, but there's a key difference. Trustees generally aren't agents for the beneficiaries. If a trustee signs a contract related to the trustee is usually personally liable on it. An agent usually binds their principal.
Oh, right. Liability is different.
Yes, but confusingly, someone can be both an agent and a trustee. Think of Royal Brunei Airlines v. Tan. Whether an agent holding money becomes a trustee often depends on whether they have to keep that money separate.
Separate from their own money.
Exactly. Channel J in Henry v. Hammond way back in 1913 set out a useful test. If you receive money and have to keep it separate, you're likely a trustee of it. If you can mix it with your own money and just owe back the same amount, you're probably just a debtor.
That's a helpful distinction. What about contracts? Trusts often involve agreements. They do, and sometimes a situation involves both, as Requick's SP showed. You could have a contract about setting up a trust, for instance. Or think about a bank account that's a contract between you and the bank, a debt. But you could then declare you hold your rights under that contract on trust for someone else.
Okay.
But the key difference is that contracts are fundamentally about mutual agreement. Trusts, especially constructive or resulting ones, can be imposed by law without everyone agreeing.
Right. The operation of law trusts. Okay. And finally, debt. You mentioned the bank account being a debt. How is a trustee holding money different from just owing money?
A standard trustee-beneficiary relationship isn't debtor-creditor. The trustee has fiduciary duties regarding the specific trust property duties to manage it properly for the beneficiaries. A debtor just owes a sum of money, full stop. They don't usually have duties about specific assets.
But they can overlap.
That absolutely can. This is where we get the fascinating Quist-Close line of cases, starting with Barclays Bank v. Quist-Close Investments.
I've heard of Quist-Close trusts.
Right. Then you have Twin Sector v. Yardley, and more recently, Ali v. Bunk. These cases deal with situations where money is lent for a very specific purpose.
Like here's £10,000 specifically to buy that machine.
Exactly. The borrower receives the money, but it's held on trust. They are both a debtor, they owe the money back if the purpose fails, and a trustee. They must use the money only for that purpose or return it if they can't. It doesn't just become part of their general funds.
Wow, okay. That really highlights how these concepts can interact. This has been incredibly useful. If someone listening is really trying to study this based on these materials, what are the absolute must-focus points?
Okay, for studying this effectively, I'd say, number one, really get the history of equity and how it relates to common law. That context is vital. Understand why equity exists.
Right, the foundation.
Second, nail down those core definitions. Settler, trustee, beneficiary, trust property. You need that vocabulary cold. Third, focus on why trusts are created. The practical reasons often illuminate the legal principles: incapacity, flexibility, pooling, protection.
Understand the why. Got it.
Fourth, know the different types of trusts: express, constructive, resulting, and crucially, when the last two arise by operation of law. Fifth, really work on distinguishing trusts from agency, contract, and debt. Know the dividing lines, like Channel J's test and Henry v. Hammond, about keeping money separate.
Spotting the differences.
Yes. And finally, make an effort to remember those key cases and judges we've mentioned. Lord Eldon on certainty in G.V. Pritchard, Bagnall J. in Coucher on applying law, not just fairness, Lewis and L.J. in Break on Fusion, Lord Mance in Acres on Ownership. They act as mental anchors for the principles.
Excellent advice. This deep dive, thanks to those University of London materials, has really built a strong foundation, I think.
Hopefully, yes. It's complex but logical when you break it down.
Absolutely. So for you listening, we really hope you'll mull over these ideas, especially that interplay between law and equity and just how versatile trusts are. And here's a final thought to take away. We talked about ongoing debates, unconscionability fusion, How do you think trust law might evolve from here? What could changes mean for how people or businesses manage things in the future?
A very relevant question for today.
Indeed. Just remember, this was all for educational discussion, and huge thanks again to the University of London for making these excellent student resources available.